So welcome everyone. Thank you for joining on a Saturday morning. Good to see so many people join in. First, let me start by introducing All India Professionals Congress because many of you might not be familiar with it. The All India Professionals Congress is a platform of the Indian National Congress that brings together professionals from diverse fields into the political process. May it be technology, finance, MSMEs, academia, sports, healthcare. We have different domain verticals on which we work on. Vinod, who has joined here, is the National Head of Technology for AIPC. AIPC primarily works on issue-based campaigns for professionals through grassroots engagements with a focus on strengthening the democratic values, inclusive growth, and evidence-based governance in India. Through fellowships, consultations, and on ground initiatives, AIPC seeks to create a space where professionals can actively participate in shaping public discourse and driving social change while actually solving issues within their domains as well. So that's AIPC for you. Happy to see all of you here. I will now hand it over to Vinod to introduce the guest and take the seminar forward.
Right. Thank you so much, Pallavi. It's always good to start with AIPC and its objectives and how we are really helping professionals. Good morning, all of you. Thank you all for joining. It's a beautiful Saturday, and thanks for making time. And yesterday was May Day, right? So it's a very important day for all the working professionals, people in whatever job that we are all in, right? Um, so as Professional Congress is a part of the IT domain, so me and a few of the folks, we thought, why don't we really talk about what are the labor rights from an IT and IT professionals perspective, right? So, and for those who don't know me or have not seen, I'm Vinod Subramanian. As Pallavi introduced, I'm part of AIPC's national team. I serve as a national head for IT/ITES domain. Currently based in Bangalore, have about 2 decades of experience in IT. Having said that, for today's topic, as we all know, we are all going through a very tough time in terms of hearing this layoff related news every now and then, right? We have seen last year, a lot of such news have come in terms of some of the IT services laying off a lot of people, and then followed by we also saw a lot of product companies also laying off people, right? And as a part of AIPC IT vertical, we have a campaign called as Together for Tech Lives. It's a campaign corely focused to address how are we going to help and support these IT/ITES professionals, right? Or professionals at large who probably are going through this sort of a tough transition, right? Uh, these these movements of layoff are probably happening because of AI. It could be one of the reason, but it's not the only reason. But what we are seeing is that people are going through this sort of a struggle, and in this transition phase, how we can really help and think about those folks, right? How we can build a safety net for the community, right? So that's what is very important for us in AIPC, and also in terms of the Together for Tech Lives campaign as such, right? So on that note, as it coincides with Labor Day, we thought there are a lot of people probably among us in our community who probably don't understand enough about labor rights, because we didn't have that opportunity to learn about it either in school, college, or probably in the professional setup, right? So we want to kind of probably see how we can help the community to understand what are the rights and entitlements are. And that's where we have a great speaker today, Avani Chokshi from IIDEA. She's also a labor lawyer, and without ado, I would request Avani to introduce herself, and then we'll delve into the topic. Avani, over to you for your introduction.
We would like to get the unique values by.
Sorry, is someone else speaking?
No, go ahead, please.
Hi, everyone. Thank you for joining today, and thank you for inviting me to speak today. I'm Avani Chokshi. I'm a labor lawyer in Bangalore. I'm also a member of AICCTU, which has our IT workers union in IDEA, IT and ITS Democratic Employees Association. So we are happy to do some collaborative work also in terms of increasing unionizing in the IT sector through whatever name. And so I'm very happy to be here, and let's go ahead.
Awesome, awesome. Thank you so much for making time, Avani. I think your experience in the related to topics related to labor law and cases that you have dealt with will be super helpful and insightful to the audience here to hear more about some of the aspects, right? So let's dive directly into the question, right? So a lot of folks probably don't know about what are the labor rights that's pertaining to IT professionals, right? So what are the different aspects that people should really be aware of from a labor law standpoint?
Thanks, Vinod. I think at the outset, it's important to understand that this lack of labor law is not only from the employee side, but also on the it's a total rampant violation of law on the employer side, which goes unnoticed in the IT sector, often because lack of knowledge, one on the part of IT workers, and also a lack of understanding that as white collar workers, we are not exempt from the label of workmen. We still have applicability of labor laws, and lofty designations don't remove us from the purview of this law. So I think broadly, it's before we begin into the benefits which labor law grants us, I think it's important to categorize ourselves into two categories. One is those who are covered by labor law and those who are not covered by labor law. So the first question to ask is, who does labor law cover? To answer this question, it's important to understand that labor law is something called welfare law. Welfare law means that there's a recognition that you are dealing with two unequal parties. For example, if you contrast that with civil law, both the parties, for example, in a property case, would be treated equally by the courts. There's no inequality inherently of bargaining power between the parties there. On the other hand, labor law inherently recognizes that there's a lower power and a lower bargaining capacity in the hands of the employee as opposed to the management. And therefore, it's welfare legislation which seeks to rectify this imbalance by giving certain additional benefits to workers. Therefore, to see who labor law applies to, labor law applies to those who fall within the definition of workman, or in the new labor codes. You might have seen that there are new labor codes. In the new labor codes, worker. But who is a worker or who is a workman? A workman is someone who performs certain categories of work. These include very specifically skilled work and technical work. So from the IT sector perspective, anyone who calls themselves an individual contributor is broadly going to fall within the capacity of workman. Now, the exclusions from the definition of workman include those who are performing managerial work, administrative work, or supervisory work. One thing to keep in mind is that especially in IT sector, many people are given the designation of team manager, team leader. Does that mean that you are excluded from labor rights? Not at all. The core issue, what the judges and what the courts across the country say, is that your designation is totally irrelevant, and similarly, any incidental work which you do is irrelevant. So if you're broadly doing skilled and technical work yourself, then even if you have certain incidental managerial duties, or even if your designation is manager, it's irrelevant, as long as you would still be entitled to the benefits of labor law. So in this context, once you recognize that I am performing skilled work, I am performing technical work, and therefore I'm entitled to labor law benefits, I think it's important to look at what are the benefits, because there's a huge range of benefits which labor law entitles to. The very first benefit to keep in mind is that I think we should first go into this entire thing we call layoffs. So layoffs, what we call layoffs ordinarily in labor law are termed as retrenchments. The retrenchments are basically a mechanism by way the company can choose to reduce its working size. This is not due to any misconduct by any of the workers. So it's important to recognize that this is not any fault of a worker. This is a policy decision of the management to reduce its workforce. And that is permissible even in labor law, subject to certain conditions. The very first condition to keep in mind is that labor law envisages that each workman is equivalent to another, which means that if you are working in the same category, the management is not allowed to pick and choose or target who it feels are problematic people unless a particular misconduct is shown by that worker. So in a case of general retrenchment, category wise, based on the number of people in your category, if there are 100 people in your category, a seniority list has to be maintained. And those who are junior most in that category have to be removed first. And similarly, if the management later decides we need more people in that category again, it has to give you an opportunity first before taking any fresh people. So this is one of the very important labor benefits, which says that first come, last go principle, that in your category, if you have come first, then you will be the last to leave in that category. And similarly, you will be given an opportunity for fresh employment before any outsider is given an opportunity for fresh employment. Secondly, supposing they do decide to go ahead and retrench you while complying with these conditions, another important condition which is imposed by labor law is that in larger establishments, under the Industrial Disputes Act, previously it was up to 100 workers, and now under the IR code is up to 300 workers. So if you have more than 100 or more than 300 workers, then you have a requirement in law. Before removing a single person, you have to take the prior permission from the government. Now, this prior permission is important because you can't remove them until you've obtained the permission. So you have to file an application for permission. You have to serve a copy to the concerned workman. The workman, represented by his union or individually, is entitled to file his objections, saying that these are the reasons for which this company is highly profitable. The decision to retrench is being taken on extraneous grounds. It's not profit motivated at all. And hence, you should not be granted permission to retrench me. And only after, and if they get this permission, they're allowed to retrench workers. This is blatantly violated by all IT sectors. There's not been a single application for permission filed, at least in Karnataka, I can tell you, by any of these IT sector establishments seeking prior permission before retrenching, which means that the retrenchments are bad in law. The third point, which we need to keep in mind while talking about retrenchments, is compensation. So there are certain preconditions to terminating a workman. One is if you are in a smaller establishment, less than 100 or 300, you have to be given 15 days wages for each year of completed service. And so this is called retrenchment compensation. You additionally have to be given 1 month's notice or pay in lieu of 1 month's notice. And very importantly, if you have raised any case against the management or if any dispute is pending where you are the concerned worker, then you can't be terminated without the permission or approval of that, wherever that dispute is pending, whether it's a court or the conciliation officer. That authority has to grant permission for your termination. So now we have covered 3 important rights. Firstly, first come, last go. First come, last go, opportunity for re-employment. Then we have covered a compensation. That compensation would be at the rate of 15 days wages per year of completed service. We have covered section 33, which says that during the pendency of any dispute, the legislature itself envisages that the management will want to target you. So if you have any dispute pending, then approval or permission of that authority would be required to be taken before you are terminated. And we have also covered the requirement of permission in larger establishments. So these are broadly the entitlements when you're talking about retrenchment. Vinod had also asked me to cover this point, but what's the taxation scene in respect of your severance? So when you're talking about workmen category, where you are receiving severance under this retrenchment head, then you are entitled to tax exemption up to 5 lakhs. Otherwise, if you are not recognized as a workman, if you are working as you call it, as a professional, or the management is trying to show that you're not a workman to evade the applicability of all these laws, then you might not get exemption and you might have to fight for that exemption by showing that you're a workman. But when you are a workman, then under section 10(10)(b) of the IT Act, you are entitled to claim exemption to a certain extent in respect of your retrenchment compensation. The other part I wanted to cover was this entire idea of performance improvement plans in the IT sector. So since I also deal with several cases of IT workers, both on one hand as a unionist and also as a lawyer, I think a few things are important to keep in mind when you're talking about these performance improvement plans. PIPs are broadly industry governed, which means they're governed by the regulations of the particular establishment. But it's important to keep in mind that we have a law called the Industrial Employment Standing Orders Act 1961. Of course, that's also been replaced now by the Industrial Relations Code. But broadly, what this law says is that workers in a certain establishment have the right to know the terms and conditions of their employment, which means you have the right to know what is the misconduct in this company, what are your leave entitlements, what are the wages of all categories of workers in the company. So these are very important rights which the Standing Orders Act gives you. As per this law, each company has to come up with something called as standing orders, which is the rules of the company. And these rules of the company have to be publicized so each and every person in the company knows what the entitlements of not only themselves, but also all the other employees are concerned. There's a high level of secrecy in IT sector where they try to prevent people from disclosing their salary. They try to create a atmosphere of fear and suppression so that workers can't come together, so that workers can't unionize. So the Standing Orders Act demands or requires that wage slabs must be made public. So everyone there's a certain level of transparency around the terms and conditions of employment. So importantly, if we move back to the idea of PIP, the certified standing orders of a company will mention what are the particular misconducts in the company. For example, underperformance may also fall within the definition of a misconduct. But just because there's an allegation of misconduct, underperformance, unsatisfactory work, doesn't mean the management can throw you out as is. There are certain pre-requirements. And the pre-requirements when they're standing orders is that if there's an allegation of misconduct against a particular worker, that worker has the opportunity to be issued a charge sheet, to give a reply to the charge sheet, and then to face something called a domestic inquiry, where an inquiry officer is appointed and the management leads its evidence on the inquiry, and the worker also has his opportunity to lead counter evidence to say that in fact I have not performed this misconduct, I have raised certain grievances, I have raised an ethics committee complaint, and therefore these allegations of misconduct on my part are totally frivolous and made up. So that opportunity is entitled, the worker is entitled to that opportunity. And even thereafter, after the domestic inquiry officer comes to a conclusion of guilt or innocence, thereafter the management again has to issue a second show cause notice. And on second show cause notice saying what is the proposed punishment, and you get an opportunity to reply. So all of these technical and procedural requirements are routinely violated in the IT sector. In Karnataka, I understand this is a all India body, but in Karnataka, it's important to note in Karnataka that the IT sector has long been exempted from the applicability of the Standing Orders Act. Now, the problem with that is that that there were certain conditions on which this exemption was granted. Some of the conditions, for example, was that you have to set up a grievance redressal committee with equal members from the workman side and management side to redress any grievance of the workers. Similarly, you have to file certain documents. Each of the companies has to give details of how many people are being terminated, how many people are being suspended on misconduct. All of these details have to be filed with the Labor Department. In fact, this exemption was extended twice. And in the last time it was extended, I believe in 2024, at that time, the Labor Commissioner in Karnataka said that IT establishments are routinely violating labor law. I do not believe that the exemption should be granted further. Unfortunately, despite and in contravention of the advice of the Labor Commissioner, the government went ahead and renewed the extension. Now, this exemption from the standing orders was valid only till the implementation of the IR code. Ultimately, since the IR code has been implemented, this exemption may no longer stand. Of course, a new exemption under the code is likely to be issued soon, but we'll have to see about that. As it stands on date, IT establishments in Karnataka would have to get standing orders certified. I also wanted to speak about certain other aspects, especially in the context of people who do not fall within the ambit of workmen. So, assuming that ultimately, even managers often face exploitative practices, they often face similar precarity and vulnerability. But as it stands, labor law is not enough to grant them relief. They are not governed under labor laws. So, what are the rights which they have in the IT sector? Ultimately, it boils down to contractual conditions when you are a managerial or supervisory staff. So, one other thing which I forgot to tell you at the very beginning is that labor law is an exemption to general civil law. So, in general civil law or common law, you do not have any opportunity to direct a management to continue to employ a worker or direct a worker to continue working in an establishment, because you can't have any specific performance of an employment relationship. So in that context, what you see is that labor law is an exception to this, because labor law sees unless you have committed a misconduct, you are equal to any other worker. So the management can be forced to continue to employ you. If you have been illegally dismissed, for example, in the labor side and you're a workman, you can go to labor court, you can demand reinstatement with full back wages, continuity of service, consequential benefits. Effectively, you can ask to be put back into the condition as if you had never been terminated at all. On the other side, when you're in the civil side of practice, for example, if you're a manager or if you're a supervisor, and if you have to claim your rights in civil court, you can't unfortunately claim reinstatement. You can claim compensation and damages for illegal termination. So what happens then is that you are, as I mentioned at the very beginning, you are not in a system which treats you as a underling in that sense, which means that you have to file a case in civil court and you will also have to pay court fees on the amount which you are seeking, the amount of compensation you are seeking. So this makes it a little bit more oppressive for the employee in question. But unfortunately, this is the situation. And to be frank, of course, we are working with higher salaried workers over here. So in our office, if you see our litigation practice, many of the factory workers we deal with are still earning around 15 to 20,000. Whereas in the IT workers we are working with are earning much higher amounts than that. And therefore, according to me, are better placed to actually fight this legal battle and choose to fight this legal battle once they know their entitlements in law. Apart from seeking compensation before the civil court, all workers, whether you are a workman category or managerial category, you have an entitlement to gratuity. So gratuity would be calculated at 15 days of service, 15 days of wages for each year of service. That is paid only if you have worked for more than 5 years, except of course now with the new labor code, if you are a fixed term employee, which means if in your contract of service there it's indicated that your service is only for 3 years, then for example, you could claim pro rata on the basis of how much you have worked. On the other hand, if you are in a terminable contract, if your contract doesn't have an end date, then you do have to have worked for 5 years before you can claim your gratuity. Yeah, someone has put a message that 4 years, 8 months. 4 years, 8 months is basically how 5 years is understood, because the interpretation of 5 years is that if you cover 8 months in the year, then it's considered as a full year of service. So that is also that's a very valid point. Then the last thing I wanted to cover before we move on to questions, I think we are at the end of our time for the discussion. But the last thing I wanted to cover is this entire idea of bond period. I think in our union, this has been one of the major issues for many of the employees, that now with the increasing precarity, they are forced to move from job to job. But these imposition of bond periods to continue working in the establishment after your notice, etc., that is becoming more and more onerous for workers. Unfortunately, you don't have a white and black answer to whether bonds are legal or illegal. The position of law seems to be that if the bond is it's unconscionable. If it's too much, then you can go to a civil court and ask for it to be set aside. But bonds per se may not be illegal. It's only in a situation where a bond is found to be too onerous or too unconscionable. Then you can argue that it's illegal. So I think broadly I've covered, given the timeline, I've broadly covered the entitlements. Maybe we can move on to questions. Let me also go through the questions which have trickled in the chat. And in the meanwhile, anyone's free to.
Yeah. Thanks, Avani, for that real summary, right? I think that sort of starts with in terms of I mean, what is our law says, who is actually a worker who is probably entitled for some of these protections or those sort of safety nets, what's currently available, and who are probably the people who doesn't fall into that category. So that was well covered. You also touched upon what are the different steps through which, if there is something going on, how they can actually go and demand for those entitlements, right? So which is also great. Um, one constant question that I always get, or probably I hear from people, is uh, some of those IT professionals, they work on SEZs, so the special economic zones, right? And some of them work on technology parks and so on and so forth. How does these laws applicable in that context, right? Is there any variation to this? What is that we should be clear about?
Thanks, Vinod. You are right that in SEZs and STPs, I'm not too sure, but in SEZs, definitely the implementation of this law varies definitely. So you do have applicability of these laws, but to give you an idea, if you were not in an SEZ, for example, if you were working in Bangalore, you have something called a labor department. A labor department is governed by a labor commissioner at the very top, and you have a detailed and intricate list of officers of various categories who govern labor entitlements. And once you have an industrial dispute, you can move a conciliation officer. For example, based on the size of your establishment, it would be either a additional labor commissioner or a deputy labor commissioner or assistant labor commissioner. You can raise a dispute, and in the Industrial Disputes Act or the IR code, you would have something called conciliation, where there would be a discussion between the parties and there would be an attempt to see if any resolution is possible. Unfortunately, when you look at SEZs, what they have is they have something called a development commissioner. And the development commissioner is given the role of implementation of all of these labor entitlements. Unfortunately, the development commissioner does not sit in the jurisdiction of the SEZ. You would have one, for example, you have a SEZ commissioner, I think, in Kerala for the full South zone. So I'm not sure how exactly it works, but it becomes extremely difficult for any workman in a SEZ to have the capacity to reach out and to seek implementation of their rights. But the rights exist. So it's not that there's a dilution of those rights. Certain entitlements for exemption, higher exemption entitlements are there, which differ from zone to zone. Yeah, so broadly it becomes more difficult ultimately.
Okay, great. So now we will probably segue into Q&A. I would request my colleague Vasu to take us further.
Sure. Thanks, Vinod. Thanks. So, Avani, Maheshwari from Haryana has a question for you. Is there any law in India that mandates companies to provide benefits such as 3 months salary or severance before laying off? What are the legal entitlements versus company policies in such cases?
So the legal entitlements, again, the law which we are discussing is the Industrial Disputes Act or the IR code as it stands. So as I discussed, you have to give 15 days wages for each year of service, and you have to give either 1 month or 3 months depending on the size of the establishment as notice pay. But unfortunately, the demanding higher than that is based on the negotiating capacity of the union. So, for example, in many of the unions which we have been able to negotiate the management up to 3 months per year of service or 4 months per year of service, depending on your equationship with the management and also the strength of your union. There's no law as such which says you have to get 3 months salary before severance in an establishment with more than 300 workers as per the IIDEA Act if you are a workman. That accompanies your permission application before the labor commissioner. But beyond that, 3 months per year of service is dependent on, of course, your union capacity.
All right, thank you. And someone, I can't see the name here. So when you say 15 days of pay per year, is it base pay or CTC is the question?
Okay, so it's neither of those two. Basically, each of these laws has a definition of wages. So you have to say the wage definition. The wage definition will have certain inclusive categories and certain exclusive categories, which means certain components would be included and certain components would be excluded. For example, ordinarily allowances are excluded, certain commissions are some allowances, DNS allowance would be included, but house rent allowance may be excluded. So based on what you are seeking, so if you're talking about 15 days of wage for the computation of the retrenchment severance allowance, then you would go to the definition of wages in the IR code and see what is included and what is excluded. It's neither just base pay, neither is it CTC.
All right. So, this is my own question, and this had come up in a panel discussion some time ago. So, say a worker is, laid off, and what are the and they do know that there is a legal recourse, but then there is a fear of being targeted for that, especially because any new employer is going to go back and ask the previous employer for a background check or something like that. So in such cases, how to deal with it? So because you know that you have to take a legal recourse, but you're also scared of repercussions. So how do you suggest one should go about?
I think that is a very valid concern. To be very frank, it's a valid concern. And each employee is going to have to take their own decision. Ultimately, the court process is not the easiest process. It takes a long time, it takes effort, it takes money, and you are not guaranteed any result, even if you have a very good case on merits. To some people, that's worth it, and to some others it's not worth it. So we, of course, as unionists, we always advocate that your litigation process should go hand in hand with your unionization process, because many things which you can accomplish through unionization are not possible through the courts, and similarly some things which are possible through the courts in terms of, for example, more onerous requirements on the establishment such as regularization or seeking a permanency, those often aren't possible through negotiation. So both of those have to go in hand. There is always victimization. When a workman goes to court, then there is some form of retaliation from the management, ordinarily speaking. And the workman has to be ready for that and can take it forward from there if they're ready to do so.
Thank you. And Praveen Kumar Natarajan is asking, the compensation which they offer, is it taxable? Also, I heard, just a moment. Also, I heard there are cases employees get 1 year salary as compensation, and for those who have worked for more than 6 years in that company, does that come under law? I mean, is what he's asking.
So compensation is taxable. As I mentioned, that it's exempt from taxation if it is layoff or retention compensation under the IIDEA Act, which means you would be able to claim exemption up to, I think, 5 lakhs if you are able to show your workman and its compensation is retrenchment compensation, which is being paid to you. Uh, 1 year salary as compensation. So basically, all of these companies have their own severance structures. Ultimately, as lawyers, we have to test whether it's less than the legal statutory compensation or more. If it's less than, definitely we can claim the balance. But many of these establishments do give higher than the statutory mandate, which means that others can't claim that as a matter of right.
All right. Thank you. And uh, someone is asking if it is possible to know whether a company has informed the labor authorities about probable retrenchment in their company.
So the companies are required, even in companies with less than 300 workers, they do have to inform the labor authorities regarding retrenchment of workers. So you would have to figure out who the jurisdictional authority is. For example, based on where you're located in Bangalore and based on the size of the company, you would be able to go to the labor department and figure out which is the official. And then you can, of course, meet the official, try and see if anything has been filed, or ultimately file an RTI if necessary. I'm not sure how this works in other states, unfortunately.
Thank you. Again, Maheshwari has another question. So, most MNCs do not allow unions within the company. Are there any national level union in India that work for IT employees? And like how to approach them, I suppose.
Okay. So I think I would have to answer this in two parts. One is no MNC has a right to tell you you can't form a union. Unionizing is your right. You have a fundamental right to association under the Constitution of India, and you have a fundamental right to even demonstrate for that matter. You have a fundamental right to gather together. So please refer to Article 19 of the Constitution and see that you do have a right to association, and any employer who's telling you that you cannot unionize is violating your constitutional rights, and you are allowed to push back on that. But in terms of national level unions, the union I'm part of is IDEA, which is ITS Democratic Employees Association. That's only one such union. There are many such unions which are doing good work on the IT side. So you'll be able to find other IT unions as well, which are working, which are basically fighting right now to create unions on this side, because this is a sector which has not seen much unionization but is seeing increased precarity and vulnerability. So definitely you'll be able to find some union to support you. Vasumati, before we go forward, can I just
Yes.
address the
Yes.
message by Abhishek Shinde about the labor codes
Yes, please.
at the very top?
Yes.
I would actually agree that
Oh,
these labor codes totally violate all labor rights. This is effectively creating a situation where the management is prioritized and your entire idea of a welfare labor legislation is gone. Because now the impact of these labor codes is that hard-won rights over decades are hugely diluted. To give you just one example, which example shall I give you? There are too many examples, but for example, if we have a 1976 law called the Equal Remuneration Act, which says that men and women performing equal work should get equal pay. But if you see the definition of wages in the new code, it specifically excludes certain components from the definition of wages for equal pay for equal genders, which means those components could be paid in a discriminatory manner, and that would be statutorily permissible under the new codes. Similarly, if you see the inspectorate system, we have inspectors, labor inspectors, who can go to establishments and can check if there's been any labor violation, and they are entitled to take action if they find a violation of labor law. What the new labor codes do is they remove the inspector and they create someone called an inspector cum facilitator, who's required to go to the management and say, please, sir, though you're violating the law, please rectify yourself. And no action would be taken against them. So these are some of the ways in which the labor codes totally dismantle the rights of the working class. On the other hand, right now, I think, especially in the context of IT establishments, right now the one main thing which the management is really upset about in the labor codes is the gratuity aspect, because the computation of gratuity till now has always been done on the basic plus dearness allowance, only that. And basic plus dearness allowance is always kept at a very low amount, which means your gratuity would be extremely low. Now, the definition of wages for computation of gratuity has totally changed, where various allowances are now included. And a proviso has been brought in that at least 50% of your salary should be within this definition of wages. So this will substantially increase the gratuity entitlement. And so this is something which managements are having a problem with.
all right. So Thanks for addressing that. I probably missed that message. So Shahid is asking if you have been asked to resign and eventually you're laid off with the reason no salary or hike budget. So can we approach the labor court?
It's difficult to say just on that fact. Have you, at the outset, I would say that people who are asked to resign should not resign. Just take your, it would be better for you to take your termination and be in a position to challenge it, because to challenge a forced resignation is very difficult because you have to prove that it was coerced. If you are intending to at all challenge the termination, better not resign at all. Just take a termination and challenge it. But you can approach labor court definitely if the conditions which I discussed earlier in this talk have not been fulfilled. For example, if it's in a larger establishment and you are in the workman category or doing individual contributor work and you have not been given the severance in accordance with law, or your junior has been retained but you have been terminated, or if you are in a larger establishment and permission has not been taken, for any of these reasons, you would be entitled to challenge the termination.
All right. So I have another question. So since we are discussing these forced resignations, so there are people who have been, put on the bench and then they're not given, and then they're asked to leave or they're terminated by showing that they have not been productive. So is there anything that the worker can do in this period, when he or she is put on the bench to collect evidence that this was done to them and they were not willingly not working? And what would those evidences be? How do I gather that so that eventually I can go forward and challenge them in court?
Again, I think this has to be answered in two stages. The first stage is in respect of this entire benching process. It is the company's responsibility to allot work to a worker who's ready and willing to work. A worker shouldn't be forced to go from team to team requesting for work, according to me. Because what the law says is you have to be ready and willing to work. Now, if the management chooses not to allot you to any team and later terminates you on grounds of your non performance, then according to me, that's a contradiction in terms. But to the second aspect of the question, that what documentation can you keep ready? I think that's a very important question because, especially in the IT sector and in IT worker cases, it boils down to what documents you have. Ultimately, to be very frank, ultimately all IT workers' cases boil down to the question of whether you are a workman or not. Because once you're a workman, you know that they're not going to have given that prior notice to you. You know that they're not going to have issued the notice to the government, appropriate government, that they're terminating you. You know that they're not going to have complied with any of these labor law requirements. So as soon as you go to court, the only battle you have to wage is to show that you're a workman performing skilled and technical work, and that you're not a manager, you're not an administrator, you're not performing. For example, now the new Supreme Court judgments would say that if you're doing creative work, you might not be a workman. So then you have to show that you're not doing creative work. Your tech work is, for example, it's a language. It's a new language you have learned. So it's a skilled work which you're performing. So for that, when you're looking for documents, whether in respect of the benched aspect or your workman aspect, it's important for you to keep copies of all documents you have, which you have access to, and to have a PDF version of them and send it to yourself and have those copies. Because often when you're terminated, your laptop is immediately taken back and your access to your professional email is immediately revoked. You don't have access to those documents, so it's important to keep those access to those documents by sending them whatever you feel is relevant to yourself. But ultimately, if you don't have documents, it doesn't mean that your situation is hopeless, because you can still, when you file your case, you can still go to court and file an application calling for documents from the management by saying that all the documents relating to my actual nature of duties or to my benching, etc., with the management. This is the list of documents which is in the custody of the management. Let them produce it before the court. And if the court so directs, then the management has to either produce it or face an adverse inference that they are not producing it in order to deny you your rights.
All right. So
Only just one, sorry, Vasu, just a question. You mentioned earlier about retrenchment is being done, and there are some reasons for it, right? Stated in the Industrial Disputes Act or otherwise. But nowadays, what we see is a lot of layoffs happening, and those companies are profitable as well, right? So it's not about anything like the company is not doing well for XYZ reasons or anything like that.
Yeah.
So what is the recourse there? I mean, is that something possible that company that is still profitable can let people go?
They do have that right. They have a right, even a profitable company has a right to change its workforce, or it has a right to rationalize subject to conditions. So what you would have to do is you have to point out why the retrenchment is unjustified. And once the case comes before the labor court not only has to look at whether there's any violation of any of these conditions, but also has to look into the question of whether the company's decision to retrench you is justified or not. So in that, all of these aspects could be brought out regarding profitability, etc.
Okay,
Mm.
sounds good. Over to you,
So,
Vasu.
thank you. So Atul wants to know if you can point us to some, documents.
Yeah.
Yeah, I think what Vasu is asking is if there are any documents about these labor laws that people can go and refer even after the session.
Sorry, I got disconnected. I'm so sorry. So I'll repeat the question. Atul wants to know if you can point us towards these labor documents specifically for IT professionals, which they can, refer to for awareness.
I'll just think a little bit more about that. There are a few articles which I could forward, but broadly it boils down. Labor laws are uh, governed mostly by judgments and very little by the act itself. So I think the main thing to keep in mind is that if you have a doubt, better not reach out to any lawyer for to clear a doubt, because civil law and labor law is extremely different. So reach out to any labor lawyer, for clearing any doubts. And maybe there are a few articles which I might have access to, which I'll send you. I'll send Vinod.
Thank you. Even if you send it over to me, I can send it across to the groups. Thanks, Avni. So I had a question, something that that can make us all feel good. Can you talk about a few, success stories, as in somebody who was laid off and they approached you or IDEA, or where you could help them?
Yeah, so we do have several cases like that, many positives and many negatives. This is not to say that it's uniformly a success story, but ultimately it boils down to what the worker really wants. Many of them really want that their background verification needs to pass. They should have a clean experience certificate. They should get an opportunity. They should get a good severance, and they should have an opportunity to go somewhere else. Many workers don't really want to go back to a hostile management. So in that sense, for people who have uh, who who want this, then we have had very many success stories where you get a better settlement, you get some clean experience certificate saying the service was satisfactory, etc. And if that's what you want, then unionizing is very helpful for that, and or approaching a labor lawyer would be very helpful for that. If you want to go back into the company, if you want reinstatement with back wages, that's a much longer ball game, because you are expecting 3 to 4 years at the labor court as a minimum. And even if you win over there, the management is without doubt going to go to high court. You might face a division bench, you might go to Supreme Court. And so you are facing a very long game of litigation, which ultimately boils down again to the workman question and the documents. So we have been successful in many cases, we have been unsuccessful in many cases, and we have many cases which are still pending. So usually it's a waiting game. It's a long process, and it's a worthy battle if you choose to face it.
So thanks, Avni. If there are any more questions, please post it on the chat. Vinod, do you have any questions?
Yeah, maybe just this is probably like forward-looking question, Avni. It's more about we see a lot of AI implementation in different organizations, especially in IT work. It's being a part and parcel of their everyday work, right? So the whole law is about labor law, right? But when that um, equation is getting changed fundamentally, right? Where do you think this is headed, right? In terms of the protection or the coverage, or because everything earlier what we had was it's about somebody physically doing something, and you trade it for money or whatever, right? So, but that labor part itself is sort of getting challenged. How do you see labor law kind of transforming from here into the future?
That's a very interesting question. And I think ultimately, I think AI is a tool. It can be used to innumerable good or innumerable harm. And right now, it's leaning towards the latter. But AI itself is only one part of the larger problem. And I think if AI is put to good use, it could be transformative. But unfortunately, the way it's being used is increasing precarity of workers, it's increasing vulnerability. And in that context, what you saw with the shift from the old labor laws to the new labor codes, which is a dilution of your entitlements, it's going to continue forward until and unless the workers are strong enough to gather together to make use of their mass, to make use of their collective bargaining capacity. And once that happens, then you're dealing with a very different ball game. But as it stands in the IT sector, this vulnerability is not reducing in the near future.
Understood. Perfect. Vasu, are there any more questions?
Uh, no, somebody had a suggestion, but I have requested them to post it on the group. We haven't seen it yet. So if there are
Okay.
no more questions, I think we can wind up.
Okay, sounds good. So, Ani, this was a great session, very informative and insightful in terms of understanding. It's like a baselining, right? We need to understand, okay, what are our entitlements? Because when somebody really goes through this sort of an experience, especially being laid off, I mean, for as an example is last week you might have got a star of the month email or something, and this week you get a different email altogether, right? So you cannot reconcile both, and a lot of people are going through this sort of a challenge. And it's very relevant and important for us to really understand what are the different legal support and safety net available. So really thank you for coming in and sharing all that wisdom about what are the labor law says, who is entitled for anything, any benefits, and also what are the recourse available. So thank you so much for that. I also want to take this opportunity to convey to everybody, right, as a part of the AIPCIT domain, we have this Together for Tech Lives campaign, which we started, and we have been pursuing it actively on multiple dimensions on how we can help the ITS fellows and professionals to figure out what is that exact safety net looks like, right? On and that's like it's like a 4-dimension thing that we are really approaching. One is personally by individuals themselves, what should be done, right? What are the preparations that they should take? Second, how do we really collaborate and partner with other organizations which are also kind of fighting for something very similar, but it's about really kind of bringing the synergies together and how we can really accomplish those objectives for the community, right? And the third is the industry bodies and the employers themselves, right? How we can really engage them in this whole proposal so that we can make sure that we can put together a dignity charter, right, for the working professionals, especially in the tech domain. And last but not the least, the important dimension is the policy making aspect, right, which is very, very important in terms of how do we really influence some of these changes in a fundamental way, right? I mean, whenever there is an issue, whenever there is a layoff, we see there are a lot of comments about a specific organization, right? I mean, there might be n number of reasons for an organization to do that, but at the same time, what we want to do is we want to look at the problem fundamentally and how that can be addressed, right? So that's where the policy making arm is coming in, where we work with the state legislature or from the union perspective to see how we can really gather some of the support and also get their attention as well into these issues. A lot of time, I believe there is not enough attention given to these issues, and we should, right? And that's also something that we are really championing. And some of the key demands that we are really fighting is how do we really institutionalize this labor rights training itself, right? I mean, in all the organizations, we do see very important trainings happening, even like the POSH trainings, right? So which is every year refresher training every employee should go through, right? But no organization we see about an organization talking to their employees about labor rights, entitlements, and no. That is very important, and we should be fighting for it and institutionalize it. But to get there, we want to do it from our own perspective. So that's where we have taken the step to kind of really bring experts in the space like Avani to come and educate us about what are the labor rights and entitlements that we should be focusing. And another key aspect that we are fighting for is the whole severance pay itself, right? I mean, the severance pay being taxed it's really, really bad, irrespective of whether you are classified as a worker or otherwise, right? So what we want to make sure is the whole severance pay should be tax exempted, because this is paid by the employer to an employee, all right, for the hardships that they will face. But it is seen as it's something you will it's something that you will profit from, which is absolutely not acceptable, right? I think there is some alarm going here. So we need to make
Even
sure
over
that
here.
we are fighting for such demands, which really helps and supports the community. Because when somebody is actually going through this layoff, it's not just them. Because in the newspapers we see 10,000, 12,000. If you just multiply that with a 4-member family, it really kind of goes beyond, right? And again, there's a lot of gig economy that gets supported by the same IT professionals, right? I mean, like your maid servants, the Ubers, the delivery folks, right? All the gig economy is supported by somebody who can afford to kind of take those services, right? So that microeconomy or macroeconomy is also getting impacted if somebody is being laid off, because
ఇదలేని
you will come back and say that
ఇంతసేపా
Vinod, you're on mute.
it's going to impact their household and their income and the whole economy as well. So there is a wave effect to the entire impact. But what we want to do is use these as an opportunity to educate everybody that this particular community is also equally important, and there should be equal attention from the policy making and the industry at large to address some of these concerns and build a safety net that is really truthful and honest, right, which serves everybody. So that's the whole campaign of Together for Tech Lives. And we have been conducting those listening circles, and we are doing listening circles, and we have planned listening circles across the country as well to hear more such points and build those solutions and build that campaign further. So I just want to kind of take this opportunity to kind of communicate all of that, as well as thanks once again, Avani, for making time this morning. Pretty informative and interesting session. I think the comments are vouching for it. So thank you so much. And
Thank
Vasu, I would invite you for a word of thanks.
So, Vinod, you have covered most of those things. So, but let me thank Avani. Thank you, Avani, for giving us time this Saturday morning, and thank you, Pallavi, for getting us all set up on FB and on all the AIPC handles. And thanks, Vinod. I know you've been a little busy, and thank you for joining. I would like to thank all the participants that came in today, and for all your questions as well. Very informative, and I learned a lot of new things as well. And thanks once more, and have a nice Saturday.
Thank you all.
Thank you.